Ready, start. In that very situation, the vital question that would arise is as to the legal sanctity of the procedure adopted by the police and, in consequence, the value to be attached to the seizures made by them on the strength of such so-called confessions. Full stop. Section 26 of the Indian Evidence Act, 1872 provides that no confession made by any person whilst he is in the custody of a police officer shall be proved against such person, unless it is made in the immediate presence of a magistrate. Full stop. Section 27, thereafter, is in the nature of an exception to Section 26 of the Evidence Act. Full stop. It states that, when any fact is deposed to as discovered in consequence of information received from a person accused of any offence, in the custody of a police officer, so much of such information, whether it amounts to a confession or not, as relates distinctly to the fact thereby discovered, may be proved. Full stop. Therefore, it is essential under Section 27 of the Evidence Act that the person concerned must be single inverted comma accused of an offence single inverted comma close and being in the single inverted comma custody of a police officer single inverted comma close he or she must give information leading to the discovery of a fact and so much of that information, whether it amounts to a confession or not, that relates distinctly to the fact discovered, may be proved against him. Full stop. In effect, both aspects, which, being in single inverted comma the custody of a police officer single inverted comma close and being single inverted comma accused of an offence single inverted comma close, are indispensable prerequisites to render a confession made to the police admissible to a limited extent, by bringing into play the exception postulated under Section 27 of the Evidence Act. Full stop. In this regard, reference may be made to Bodhraj alias Bodha and others versus State of Jammu and Kashmir, within bracket 2002 bracket close 8 SCC 45, wherein this court had observed that the requirement of single inverted comma police custody single inverted comma close is productive of extremely anomalous results and may lead to the exclusion of valuable evidence in cases where a person, after committing a crime meets a police officer and states the circumstances of the crime which lead to the discovery of the dead body, weapon or any other material fact, in consequence of the information thus received from him, and he is subsequently taken into custody and becomes an single inverted comma accused single inverted comma close full stop. This court pointed out that this information, which would otherwise be admissible, becomes inadmissible under Section 26 of the Evidence Act, as it did not come from a person in the single inverted comma custody of a police officer single inverted comma close, or rather, came from a person not in the single inverted comma custody of a police officer single inverted comma close full stop. In other words, the exact information given by the accused single inverted comma while in custody single inverted comma close, which led to recovery of the articles can be proved full stop. It was noted that this doctrine is founded on the principle that if any fact is discovered as a search was made on the strength of any information obtained from a prisoner, such a discovery is a guarantee that the information supplied by the prisoner is true. Full stop.